Good day. For this session, I will discuss to you the gaps in international law concerning climate-induced displacement and relocation. Let me share with you our discussion outline for this session. First, we will look at the nexus of human rights, climate change, and migration, and then we will slide to the impact of the limited definition of refugees in international law, and afterwards, we will look at an attempt to redefine the legal regime concerning climate migration. Given the limited time, this presentation is not meant to be a comprehensive list of gaps in international law. Rather, I intend this presentation to invite you to begin to consider how else we can improve our international legal regime to protect those displaced by climate-related events. When the Universal Declaration of Human Rights expressed in its very first article that all human beings are born free and equal in dignity and rights, it implied that the core of human rights law is the recognition and respect for human dignity. It is said to be the source from which all human rights originate and that which unites other human beings and human rights into a whole. Human dignity, as defined by the Oxford English Dictionary as a quality of being worthy or honorable, was historically ascribed only to a privileged few. The UDHR, or the Universal Declaration, however, repudiated that long-standing view and reintroduced dignity as inherent in one's humanity, recognizing no race, color, sex, religion, or other status. Human dignity was reimagined as a birthright, such that merely being human makes one deserving of respect. This modern conception of human dignity was widely accepted and were adopted by most states in their own legal systems. In the Philippines, this is engraved in Section 11, Article 2 of the 1987 Philippine Constitution, which states that the state shall value the dignity of every human person and should guarantee full respect for human rights. Okay. While there is yet to be an explicit definition of human dignity, as its intrinsic meaning is often left to intuitive understanding, a state is nevertheless guided in recognizing a possible violation of human dignity through a list of human rights contained in international instruments. These bundle of rights, which are universal, indivisible, and interdependent with one another, when protected and guaranteed by the state, will carve a path for one to enjoy a dignified life. It has been recognized that a clean, healthy, and functional environment is crucial to the enjoyment of human rights, particularly the rights to life, food, shelter, and an adequate standard of living. States then are required to create systems or mechanisms that will provide its citizens the necessary resources to attain an environment that is of a quality that will allow them to live a life of dignity. States, however, are currently facing a major challenge in creating such an environment: climate change. Climate change is a human rights problem. Arguably, it is the greatest human rights challenge of the 21st century. Climate change and the people's response to it have made profound impacts on the enjoyment of human rights across the world. Extreme weather changes that directly lead to deaths, destruction of property, environmental degradation from which many livelihoods depend on, limited access to food, water, shelter, and indirectly, unlimited access to healthcare and education, among others. While entire populations are already experiencing and suffering the impacts of climate change, its impacts are disproportionately felt. As noted by the Intergovernmental Panel on Climate Change, the people who are socially, economically, culturally, politically, institutionally, or otherwise marginalized are especially vulnerable to climate change, and also to some adaptation and mitigation responses. Indeed, the impact of climate change has severely impacted the marginalized sectors who are incapable of moving themselves out of harm's way, resulting in their displacement. Climate change can lead individuals to relocate either temporarily or permanently, domestically or globally, spontaneously or systematically, freely or involuntarily. Migrants may be categorized as either internally displaced persons, stateless persons, or individuals. These distinctions of migrants are important to consider. For instance, the distinction between voluntary and forced migrants has always implied that the latter should be permitted to travel, or at the very least, should not be forcibly returned to their nation or region of origin. For this presentation, we will give more focus to international refugee law. However, it would be good to distinguish refugees from internally displaced persons at the beginning. The Office of the High Commissioner for Human Rights reported that displacement is triggered in 4 ways: weather-related events, gradual environmental deterioration, and slow-onset disasters. Increased disaster risks resulting in relocation of people from high-risk zones, social upheaval and violence related to climate change-related factors. According to the Internal Displacement Monitoring Center, 98% of the displacement which occurred between 2008 and 2012 took place in developing nations, many of which are not only disaster-prone but also lack the capacity to deal with when disasters strike. This suggests that while these 4 factors contribute to the displacement, it is a state's inability to respond that provides the final push for individuals to flee. While there are no reliable global estimates of future population movements linked to climate change impacts, much of the literature shows that the likelihood of displacement would rise due to the amplifying effect of climate change on disaster frequency and severity. Internally displaced persons are defined as those forced or obliged to flee from their homes, in particular as a result of or in order to avoid the effects of armed conflicts, situations of generalized violence, violations of human rights, or natural or human-made disasters, and who have not crossed an international recognized state border. Considering this definition, persons who are displaced due to climate-related events who do not have to cross international borders may fall under the conception of internally displaced persons. On the other hand, the 1951 Convention relating to the status of refugees and its 1967 Protocol provide a relatively narrow definition of a refugee. That is, a person outside his country of origin to which he is unable to return, owing to a well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group, or political opinion. The Refugee Convention does not and was not designed to cover all immigrants in need of protection. International refugee law, according to James Hathaway, in fact rejects the ideal of full protection for all involuntary migrants. People who have fled their nations due to climate change do not qualify as refugees because, number one, they do not meet any of the definition's 5 criteria, and second, their vulnerability to the effects of climate change does not fall within the designation or the criteria of persecution. The current refugee law viewpoint has resulted in a situation in which most people in need of international protection must accept whatever voluntary emergency help is given for them through official or non-profit initiatives. Consequently, international migrants who do not qualify as refugees may face more frequent or abusive treatment. While specific international human rights mechanisms have been enacted in recent decades to protect international migrants who have been subjected to abuse, the growth of such protection has been hampered by a lack of developed country support. Worse, these countries have devised strategies aimed at preventing asylum seekers from claiming refugee status, such as imposing sanctions on non-authorized migrants transporters, investing significant resources in border control and surveillance, and forming partnerships with buffer countries. While most people displaced by climate change may be generally considered as internally displaced persons, those who need to cross borders do not anymore fall under the definition of IDPs. But given our earlier considerations, they also do not fall under the definition of refugees. Considering the principle of universality of human rights, the rights of climate migrants also need to be protected. This case involving New Zealand, which was previously discussed in Session 2, highlights this. Let me reiterate the pronouncement of the Human Rights Committee. The committee is of the view that without robust national and international efforts, the effects of climate change in receiving states may expose individuals to a violation of their rights under Article 6 or 7 of the Covenant, thereby triggering the non-refoulement obligations of sending states. Furthermore, given that the risk of an entire country becoming submerged underwater is such an extreme risk, the conditions of life in such a country may become incompatible with the right to life with dignity before the risk is realized. Migrants' human rights should not be restricted to a determination of their right to enter and remain in a new location. Migrants should take their rights with them. However, as previously stated, the effective exercise of these rights is frequently hampered by precarious status at the point of arrival. Individuals, regardless of their position as migrants, are covered by general international human rights law. While nationality may be required for entry or residence in a country, as well as participation in electoral processes, all other human rights apply to everyone within the territory or within the jurisdiction of a state. Discrimination based on national origin or other status is clearly prescribed by both the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights. Therefore, migration status should not be a criterion for the enjoyment of human rights. Human rights extend to internally displaced persons, and the guiding principles on internal displacement adopted in 1998 provide an authoritative interpretation and synthesis of the related obligations of states. The urgent need for climate migrants to have effective protection and support from the international community has prompted Frank Bierman and Ingrid Boas to propose a different global governance regime for the recognition, protection, and resettlement of climate migrants, which will be a key component of the emerging global governance architecture on climate change adaptation. Bierman and Boas proposed the creation of a new legal instrument, possibly a protocol on the recognition, protection, and resettlement of climate migrants under the existing United Nations Framework Convention on Climate Change, or the UNFCCC. That will be based on 5 principles. First, the principle of planned relocation and resettlement. Relocation and resettlement cannot be done on an ad hoc basis, especially in countries or territories frequented by severe weather events. At the core of a regime on climate migrants are thus not programs on emergency response or disaster relief, but rather planned and voluntary resettlement over much longer periods of time. Second, the principle of resettlement instead of temporary asylum. Climate migrants cannot return to their homes in case of severe climate impacts. As such, the idea that political refugees can return to their countries once the persecution is over cannot be applied. There is a need for an institutional design that conceives of climate migrants as permanent immigrants to the regions or countries that accept them. Third, the principle of collective rights for local populations. Following the usual conception of refugees, they are protected on an individual basis. Even assuming that an entire people is persecuted, the Refugee Convention is designed for an individual state-based persecution. A climate migration regime, however, would need to be tailored for collectives of people, such as populations of certain villages, cities, regions, provinces, or, as in the case of small island states, of entire nations. Fourth, the principle of international assistance for domestic measures. Climate migrants enjoy, in principle, the protection of their own countries, and in many cases, serious climate change impacts will affect only parts of a country. Thus, an international regime for climate migrants will be less on the protection of persons outside their states, but rather on the support of governments, local communities, and support agencies to protect people within their own territory. International assistance and funding for these domestic support and resettlement programs of affected countries should be made available when such support is requested by these countries. Fifth, the principle of international burden sharing. The protection of climate migrants, according to Bierman and Boas, requires the adoption of institutional elements from existing agreements on climate or from similar areas. It could be based on widely accepted ideas like the shared but differentiated responsibilities, the reimbursement of incremental costs of affected countries that occurred through resettlement of climate migrants, double-weighted decision-making procedures. It could help protect climate migrants by tying their protection to the wider climate regime, such as advancements in climate science that define dangers for people in specific areas. It must be noted that regional instruments following these 5 principles may also be adopted. This could well be a faster and more efficient solution to aid the plight of climate migrants across the world in different regions. Let me end by saying or reiterating again that our discussion in this session is not meant to be a comprehensive list of gaps in international law pertaining to climate-induced displacement and relocation. This presentation is again an invitation for you to begin to consider and think about how else we can improve our international legal regime to protect persons who are displaced by climate change-related events. Thank you once again and good day.